ownership in the goods has already been transferred, or where the ownership in the goods is yet to be transferred. So in that particular situation, the rights of unpaid seller would differ. So in that scenario, we discussed that when we talk about rights of unpaid seller, the rights can be against the goods and rights can be against the buyer personally. When we talk about rights against the buyer personally, there the buyer can file, seller can file a suit against the buyer for price, that is for the performance of the contract, because goods have already been given. This particular situation might happen in those circumstances wherein the goods are specifically designed for the buyer, or the goods cannot be come into the original position again, or goods have been consumed by the buyer, or the particular goods are of that thing that these cannot be resell by the seller. So in those situations there cannot be the adequate remedy other than the performance, and the performance can be in terms of payment of price. Then also if there is a situation that the ownership in the goods has not been transferred, but the possession of the goods is with buyer, or the goods have been designed for the buyer, but these can be, against be sold to someone else, but again there is certain price differences there, some loss is there, or some cost or service is being involved. So in that situation, the seller can file a case for the claim of the damages, and generally it happens in case of agreement to sell, where ownership in the goods has not been transferred to the buyer. Then also when we talk about breach committed by the buyer, then the seller, to be on safer side, can also file a suit for the cancellation of the contract or setting aside the contract. So as per this particular suit, seller is also discharged from his legal obligation to perform the contract. Then there is, if the money is involved or investment has been made, or some amount of interest or penalty is there, so suit can be filed for that as well. When we talk about right against the goods, right against the goods means that the how the particular seller is going to treat the goods. So if the goods are with the seller, so there is a different situation. If the goods are with the buyer, there will be a different situation. But when we talk about the circumstances, that if the ownership is transferred, that is in case of sale, the seller will have the different rights. And if the ownership in the goods has not been transferred, then in that case the situation would be agreement to sell, and the seller will have different rights. In case of sale where the ownership has been transferred, the seller will have right of lien, right to stop the goods in transit, or right to resell the goods. So in this particular case, we have already discussed right of lien, that is right to retain the goods belonging to another for the claim of the price, or for something which has been done with respect to the goods. So in this case, this particular right can be exercised only when the possession of the goods is with the seller. If he loses the possession, right of lien cannot be exercised. We have also discussed the concept of the general lien and particular lien as well, and also discussed the situations where the right of lien is lost or termination of lien is there, or under what circumstances this particular right can be exercised by the seller. Then in continuation, we have to discuss that what do we understand by right of stoppage in transit with respect to the goods. When we talk about right of stoppage in transit, so stoppage in transit itself means to stop the goods in transit. That is to stop the goods in transit. So when we talk about the transit, so it means that the goods have left the place of the seller, but the goods have not reached the place of the buyer. So goods are somewhere in this particular phase where we say the goods are in transit. So when this particular right can be exercised, this right can be exercised when the goods are in the course of transit. It means have left the place of the seller but have not reached the place of the buyer. So here we have to understand What do we mean by this particular right? When this particular right can be exercised and when this particular right cannot be exercised. So these three things or three aspects we have to understand with respect to right of stoppage in transit. When we say that this particular right is to be exercised, the condition is that the seller must be an unpaid seller within the meaning of the act, within the meaning of section 45. So here we say that the right of stoppage in transit is a right of stopping the goods in transit after the unpaid seller has parted with the possession of the goods. अगर possession में होती goods तो हम right of lien exercise कर लेते, goods को हम retain कर लेते. But because the goods have already been dispersed or have been started for the place of the buyer, so in this particular situation, the seller cannot exercise the right of lien. But because the goods have not reached till the place of the buyer, so the seller has the possibility to resume the possession of the goods as long as they are in the course of the transit and retaining possession of the goods until payment or tender of payment of the price. So it means that goods can be taken back, can be kept back, or can be asked the delivery person to bring back to the place of the seller to when till the time the payment is being made or payment is being offered by the buyer. So this will be known as the right of stopping the goods in transit. So this particular right can be exercised only when the following circumstances are or following conditions are satisfied. The first one is the seller must be unpaid. Second is the buyer must be insolvent and the seller must have parted with the goods with the possession of the goods and buyer must not have acquired. The goods should be in transit. So in this particular situation, if the goods are in transit and seller is unpaid seller, the goods can be stopped and can be taken back. But at later stage, when because the ownership has already been transferred to the buyer, so in that particular case, the official receiver can ask for the goods. Then there is transit. What do we mean by the transit? So transit is considered as an intermediate state that is in between the from point A to point B. So this particular in between the point, the intermediate stage is called as the duration of transit. But in this case, when we say that the duration of transit is not there, that if we have given the delivery to the agent of the buyer, right? Or if the transit person have communicated to the buyer that he is carrying goods on his behalf to be delivered at his place. So in all these situations, transit comes to an end. So in this situation, the buyer or his agent take the delivery of them from such carrier, or it is not been communicated till the time it is considered that goods are in transit. So we have to understand the meaning of transit itself to exercise this right. Now we say when the transit comes to an end, if there is interception by the buyer and delivery to the buyer. For example, the goods have started moving from point A to point B, right? So this is A is the seller and B is the buyer. So before the goods reach, in between, the buyer meets the transit person and have taken the delivery of the goods. So as per law, this is the transit period. The seller can exercise the right, but if it is in between, it has been intervened by the buyer and buyer has taken the delivery, the transit will come to an end here. So you cannot exercise the right beyond this particular point. So if there is interception by the buyer or delivery to the buyer, the transit will come to an end. Hence, seller cannot exercise the right of stopping the goods in transit. Second is acknowledgement to the buyer. As discussed earlier, that if the agent or if the carrier person have given a call to the buyer or have communicated to the buyer that he is carrying the goods on his behalf, then in that particular case, the carrier will become as a bailee who is carrying the goods as a bailee in safe custody, and he has got the duty to deliver the goods at buyer's place. So in all these situations, wherever the acknowledgement is being given to the buyer, transit comes to an end. Then, where the carrier or other bailee wrongfully refuses to deliver the goods to the buyer or his agent in that behalf. So, अगर wrongfully उसने मना कर दिया, तो उस केस में भी transit will come to an end because the goods have reached, or the buyer have got the right to receive the goods, but the carrier have refused wrongfully. So in that case, it does not take away the right of the buyer to claim the goods. The goods will belong to the buyer and the transit would come to an end. Then the delivery on ship chartered by the buyer. So if the carrier person is of buyer only, or generally in case of the export of the goods, if the ship is chartered by the buyer, then in a particular case, what will happen? That we are giving the goods to the buyer or buyer's agent. So in that particular situation, the transit will come to an end and seller cannot exercise the right of stoppage in transit. Then when the part of the delivery is being made to the buyer and it is being communicated, so in this particular case, the whole delivery, whole and seller can stop the in case of remainder of the goods can be exercised. Otherwise, if it is communicated that he is carrying the remaining goods as well, then in that case, exercise right of stoppage in transit cannot be exercised for the remainder of the goods. Then we say that how the seller is going to exercise the rights of stoppage in transit. So in this particular case, one thing is that we can communicate, we can take actual position of back of the goods, or we can give a notice to the carrier that the goods belongs to the seller only and he is supposed to return the goods. So in this particular situation, the liability of carrier arises. Right? So in this case, once the seller has exercised the right of stopping the goods in transit and he has duly communicated either by notice or by communicating the otherwise, then in that particular case, it is the liability of the carrier to return back the goods to the seller. तो अगर उस केस के अंदर गलती से वो फिर भी बायर को डिलीवर कर देता है, then the carrier will be held liable for the loss or getting the goods back from the buyer to the seller. So in this particular situation, the legal liability of the carrier will arise. Then how this particular notice can be given? The notice can be given either to the person himself who is carrying the actual possession of the goods or to the principal. So generally we say that there are the courier companies. So we do not know who is carrying the actual goods. So if we have informed the company, or if we have informed the principal who is getting the particular things delivered, so it is considered as the required notice, or it is considered as the valid notice for the exercising this particular right. If the notice is given to the principal, it must be given at that time when it is possible to communicate his agent to stop the delivery. If the circumstances are such that principal cannot communicate the agent to stop the delivery, then in that case, right of stoppage in transit cannot be exercised, or carrier cannot be held liable for delivering back the goods to the seller. Also, when the notice is given by the seller to the carrier to stop the goods, the carrier should re-deliver the goods or according to the directions of the seller. So, liability of the carrier arises in this particular case. So, if the carrier, after a proper notice by the seller to him, stop the goods in transit, delivers them to buyer, or refuses to deliver them to the seller, he is liable to the seller for conversion or wrongful appropriation of the goods to another. If after the transit ended, he wrongfully returns the goods to the seller, he is liable to the buyer for the conversion. So it is the duty of the carrier to, in case it's required, to get back the goods. Then we say this is not to be done. Let's skip this. Then this is very important right. Third right, that is right to of resale. So right, first right we have discussed right of lien. The second right we have discussed the goods of stoppage in transit. And the third is right to resell the goods. So this particular right can be exercised in case of finder of goods as well, right? This right can be exercised where the goods are of perishable nature, and this can be right can be exercised when the goods are in the possession of the seller and the goods are but the seller is an unpaid seller. So with giving a notice to the buyer, the goods can be again be sold to someone else. A contract of sale is not set aside when the seller exercises his right of lien or stoppage in transit. The contract still remain in force, but buyer can claim delivery of goods by paying the price. So seller cannot resell the goods just because he is unpaid seller. It is open to the buyer to take the delivery of the goods by paying the price at any time. But as per section 54, in the following circumstances, goods can be again sold to someone else. That is, if the goods are of perishable nature, the goods are in possession of the seller and seller is unpaid seller, and by giving a notice to the buyer that if he doesn't collect the goods within a reasonable time period, the seller is going to sell the goods to someone else. So in this particular situation, the following circumstances are there where goods can be again sold by the buyer. Goods are of perishable nature, then the unpaid seller gives a notice to the buyer, and the right of the unpaid seller where the ownership of the goods is not transferred to the buyer. So in this all these circumstances, the right to resale can be exercised by the unpaid seller. Then other than this, if we talk about the initial slide, let me come here. If we talk about this particular slide, right of lien we have discussed, right of stoppage in transit we have discussed, right of resale we have discussed. In case of agreement to sell where ownership is not being transferred to the buyer, so in this case stoppage in transit right can be exercised. This right is same as we have discussed here, section 50 to 52. Withholding delivery means that if the goods are with the in the possession of the seller, so he can continue to retain the possession of the goods, and if the goods are in the possession of the buyer, then he can demand back and take back the goods from the buyer. So withholding delivery means that if he is yet to deliver the goods, he can withhold the delivery, and even if the goods are in the possession of the buyer, he can take back the goods from the buyer itself. Then we come to the last topic which we have already discussed, that is suit for damages for repudiation of contract before due date. So this is, yeah, this is the second part, right against the buyer, though I have discussed in journal. So let's see it quickly. That rights against the buyer. So where the buyer has not paid the price, then suit for price can be filed against the buyer. Then suit for damages for non-acceptance of the goods can be filed against the buyer. So if he has not accepted the goods, you have incurred certain kind of expenditure in making the goods or designing the goods, even though you can resell the goods in the market, but still if you, any damages or any, we can say, cost or loss is suffered by the seller, it can be claimed. The suit can be filed for the same. Then we say that when a seller is ready and willing to deliver the goods, that is the tender offer is being made by the seller, and the buyer refuses to take back the goods, and in this particular situation the buyer is liable for any loss which is suffered by the seller because of the refusal to take the delivery or reasonable charge or care for the custody of the goods. So here I can give you an example. If we talk about the automobile industry, so to keep the car or to maintain the car, there is the expenditure is involved, huge expenditure is involved. So suppose the car is to be delivered on 15th of Feb, and in this particular situation the buyer has refused to take the delivery of the car and it got delayed by 1 month. So he is going to take the delivery on 15th of March. So any expenditure which has been incurred or met by the seller for taking care of the custody of the goods, it will be met by the buyer. So suit can be filed for claiming this particular price. And if there is any loss because of the acceptance of the delivery of the goods or anything happens, then the buyer is responsible for the loss, because when we talk about tender or valid tender or offer to perform, it is considered as equivalent to performance. This particular thing we have already discussed in the chapter of performance in case of Indian Contract Act. Then if there is any kind of repudiation of contract before the due date, then it is a clearly a breach of contract, and we also call it as the actual breach and anticipatory breach, right? So in this situation, if there is any breach, so then in this particular situation again the same rule will apply, that either you can wait till the time of actual performance of the contract, or you can file a case that moment only. Then suit for interest or special damages. So if there is any specific agreement with respect to the interest or damages, it is being communicated, then the seller can file a case for the same. Then rights of the buyer in case of breach by the seller. So if seller is not performing, or seller has not given the delivery of the goods, or seller has not given the transferred the ownership in the goods, or any of the conditions have not been met, so there is breach by the seller. So how the buyer can exercise his right in that particular situation? So here the suit for damages for non-delivery can be there, suit for specific performance, that the seller is required to perform the contract, required to give the ownership in the goods and the possession of the goods to the buyer. Then in the continuation, there can be suit for damages for breach of warranty. This we have already discussed. Then suit for rescission of contract and for damages for breach of condition. So when the conditions are not being met, or breach of condition is there, the buyer has the right to set aside the contract. So he can file a suit for setting aside, and also will claim the damages for the breach of condition. And also if the condition is not being met, buyer has set aside the contract, so he can file a case for the recovery of the price along with the interest in the particular case. So the cases, this we have already examples we have discussed, but the specific cases we are going to discuss when you are going to cover this particular topic in your presentations, right? So from my side, this particular Sale of Goods Act is over, and in case you need any topic to be discussed in detail again, so we can take up